Before we go ahead, ladies and gentlemen, there is a small disclaimer. This presentation and webinar is solely for information purpose and to create awareness, and it should not be treated as a legal advice. Since we are discussing an act or law, there are so many other repercussions of treating it as a legal advice. So please don't take it as a legal advice. This is for generation of information and awareness among all folks. With this, ladies and gentlemen, I come to the introduction. Today, I am the host. I'm Janardan Khadilkar. I'm Indian Army veteran. I've put in about 21 years service in Indian Army. Presently, I'm working as project manager at Tekdi Technologies Private Limited and looking after the vertical of information security, cyber security, and project management. We also have Mr. Karan Dodeja, who is a senior legal advisor at LegaLogic Consulting. Karan is a data privacy lawyer. His core area of expertise involves implementation of data privacy frameworks at an organization level and advisory on compliance with data protection laws. We are also joined by our third speaker, Mr. Manoj Londhe, who is a tech manager at Tekdi Technologies Private Limited. He is having more than 14 years plus experience. He has led major projects and contributed to 30 plus products. He comes with an experience of ensuring technical applications and projects requiring compliance standards for notable international standard projects. Before we move on, ladies and gentlemen, we have already muted all the distant end participants for the ease of conduct of seminar. At the end of the seminar, we will open it for the Q&A session. I will request the person who is asking the question to give out his or her name and the organization which he or she belongs to. If the person is comfortable, he or she may switch on the camera and ask the question. It is for the ease and better understanding for all the participants of the webinar. So here comes the agenda of the today's webinar. Friends, we'll be briefly introducing about the act, what this act is all about. Then we will request Karan to give the legal perspective about it. After that, I'll be focusing upon some industry-wise impacts which this act is likely to cause. Then Manoj will give us some technological perspective with his background while implementing certain GDPR related issues. And finally, we will open the house for question and answer session. Friends, with the implementation of GDPR for the European Union, there was also a talk going on in India to have a robust framework for personal data protection. So in 2019, the government actually announced and introduced the Personal Data Protection Bill. In 2020, the initial version was prepared. However, the implementation slightly got stalled because of the outbreak of COVID-19. In 2021, the initial report was published and the draft Digital Personal Data Protection Bill was published finally in 2022. 11th August 2023 was the day when this particular act got notified. Now it is in a gazette form available in the open source and it has been notified as an act or law. Friends, this act is for the processing of digital personal data. Whatever it is in the digital form, this act is about that. This act processes the digital personal data in a manner that recognizes both the rights of the individual to protect their personal data, as also it's a comprehensive privacy and data protection law that recognizes rights of the individuals also. Since this is an act or law, let's go to our legal expert who will throw some more light on the legal perspective of this. Now, I hand over to Mr. Karan Dodeja for giving out the legal perspective. Karan, over to you.
Thank you, Janardan, for this introduction, providing us with a historical perspective and a brief introduction about the DPDPA. And good evening, everyone. So today in this part of the discussion, we'll be focusing upon decoding the DPDPA. We'll touch base upon the applicability, key stakeholders, grounds of processing personal data, the nuances associated with consent privacy notices, obligations that are mandated by a law on the organizations that process personal data in the capacity of a data fiduciary. We'll check upon certain rights and duties that are awarded on a data principle. We'll check on the financial penalties for non-compliance. And finally, we'll also discuss on the key takeaways to ensure smooth compliance. So to get started with decoding of the data, DPDPA, let's first understand the applicability of the law. So next slide, please. Okay. So prior to understanding the applicability, let's understand personal data, which is at the core of the Act. So how personal data is defined under the Act is very important. Personal data has a broad definition. It is non-prescriptive in nature. It says that any information that helps you identify an individual will be termed as personal data. So examples of such personal data could be simple as your name, email address, phone numbers, your physical address, any information that helps you identify as an individual. It could be simple as your employment data related to your job titles, resume, social identifiers on social media platforms, information about your government documents such as PAN card, Aadhaar card, passport, driving license, information related to your bank account numbers, credit card numbers, your financial data, any health and medical data. So all any information that helps you identify an individual is termed as personal data. Under the Act, there is no specific segregation on personal data or any health or any sensitive data. So any type of information that helps you identify as an individual is termed as personal data. Having understood about personal data, let's understand the applicability of this Act. Next slide, please. Yes. So this Act applies to processing of personal data in a digital format. So throughout my presentation, I'll be using the term processing throughout. So what does this mean? What does this term indicate, process and processing? So under the Act, the term process means any operation that we undertake on a data. So that could be as simple as even if you access the data, you store data, retain data, disclose data, share data. So all such activities is termed under processing. So for example, if you store your data on AWS cloud server, so such storage related activity will also come under the definition of processing. Or even if you disclose personal data to any third party, that would also come under the term of processing or simple access to data through a VPN. So here the Act applies to processing of personal data in a digital format. It does not apply to personal data that is processed in physical form. So for example, all your physical forms or all the data records that you maintain is in a physical format are exempted from the applicability of this law. Any physical document which is digitized at a later date, this Act also applies on that personal data sets. Having understood the type of data, let's understand whether this Act only applies to organizations that are based in India. The answer is no. The Act also applies to organizations that are based outside India and as part of their goods and services offerings, if they access any individuals or Indian residents' personal data or process personal data as part of their offerings, they also fall under the compliance requirements of the law. So this Act has an extraterritorial applicability. It applies to organizations that process personal data within India as well as to organizations that process personal data outside of India as well. There are certain exemptions associated with the applicability of the Act. So, any personal data that is processed for personal or domestic purpose is exempted. Similarly, personal data that is voluntarily made available by an individual in the public domain is also exempted. So, for example, any your social media handles, so data disclosed on LinkedIn, uh, companies, directors, information set out on MCA websites, or any blogs that you share out on social media platform, or any data that you are being asked to share in the public domain under a legal obligation. So all these activities wherein there is a voluntary submission of data in the public domain has been exempted under the law. Having spoken about the applicability, let's understand the key stakeholders under this act. Yeah. So at the core, you would see that there is a data principal. So data principal is nothing but an individual, such as you and me, whose personal data is being processed by organizations as part of their day-to-day operations. Now let us understand who these organizations are. There are two types of organizations, data fiduciaries and data processors. These are functional concepts. They basically identify the responsibilities of on the parties. So when we speak about data fiduciary is a determining party, or you may say an organization that determines the means and purposes of processing personal data. To understand this in a better way, let's take help of an example. So, for example, I on my website, I am an organization. On my website, I receive inquiries from prospective clients about my product, and I have a feature of providing them with a demo. So here I get to decide, and as part of registering for a demo, I ask individuals to submit their name, email address, as well as their company details, designations, so on and so forth. So here I, as an organization, get to decide whether this demo will be provided to these individuals by internally by my team, or I outsource this functionality of providing demo to a third party service provider. So I determine the means and purposes of providing this demo. Similarly, when during an onboarding stage of an candidate to an employment, so during the entire onboarding or during the entire recruitment stage, there are various aspects. And there is a BGV kind of an aspect, and there is an interview also happening. So here also I get to decide that how can I use this candidate's data, whether I outsource the BGV background verification activity to a third party service provider, or I take a help of a platform that provides interview as a service. So where an organization gets to determine the means and purposes, where there is a lot of autonomy in taking decisions in relation to how to process the data, there that organization will be termed as a data fiduciary. The next organization is data processors. So data processors are nothing but your service providers, vendors. They are the acting party. They act on the instructions of the data fiduciary. So carrying over the same example, if for providing a demo, I take help of a third-party service provider or a platform, so that particular third-party service provider would be termed as a data processor. Similarly, during the recruitment stage or the employment stage, the parties or the service providers that help me or provide the required assistance for conducting the functions would be termed as the data processors. So they basically act on the instructions of the data fiduciaries. There is a new term coined under this act of a significant data fiduciary. So here the regulator will decide depending on various thresholds. Now these they will determine whether a organization falls in the category of a significant data fiduciary or not. So there are certain thresholds. These are These are basis the volumes and the sensitivity of the data process, whether their processing activities fall under the category of sovereignty of the state, they have any privacy implications, they are associated with the security of the states, and so on and so forth. We'll check a few examples of data, significant data fiduciary in the next slide. You may go to the previous slide, Janardan. Yeah. So here the other aspect is the data protection officer. So here the appointment of a data protection officer would be notified by the regulatory authority. The data protection officer is a liaison officer that acts as a liaison officer between the regulator and the organization. It also looks after the compliance requirements of an organization. The next term is the consent manager. This is also a new term. Here, the consent manager is nothing but an external entity. They are regulated entities. They need to register with the board, and their key task is to manage the consents of the individuals. So wherever in organizations where there is a huge flow of data, there these consent managers will play a role wherein they'll manage the collection of consents and the overall consent life cycle of the data principle. So these consent managers should have the expertise, the wherewithal, the technical expertise to manage and address the consent requirements. Finally, we have a new dedicated regulator, that is the Data Protection Board of India. It's in a digital office format. We'll uh, We'll also speak about the regulator in upcoming slides on regulatory and enforcement actions. Next slide, please. So as we were discussing about significant data fiduciary, as I said, there are certain thresholds depending upon the volume of the data that they process, depending upon the risk to privacy, security aspects, if there are any risks to electoral democracy and public order. Uh, Currently, these thresholds are yet to be notified by the government, but we think with the type of volumes that an organization will process, organizations like B2C companies with large user base may fall under the category of a significant data fiduciary, e-commerce company or banks, organizations in the healthcare space, defense and security space, social media companies, so on and so forth. There are certain additional obligations which are associated with a significant data fiduciary as compared to the regular data fiduciaries. They are in relation to conducting audits, appointment of DPO, so on and so forth. Having understood the stakeholders, let's now dive deep on the next aspects. Next slide, please. Next slide, please. Yeah, thank you. Let's understand what are the grounds for processing of personal data. So, the DPDPA Act basically recognizes two grounds for processing personal data. So these grounds are consent and legitimate interest. So any of our data processing activities, if they are based on consent, they would be considered lawful in nature. Similarly, processing which are based on the other ground is certain legitimate use also, where we may process the personal data without obtaining consent of an individual. Let's understand in detail the nuances which are associated with consent as a ground of processing personal data. Next slide, please. So the Act sets out certain requirements when we are relying on consent as a ground for processing personal data. So the first and foremost requirement is that whenever we are obtaining consent, now consent is nothing but a permission that we obtain from an individual for processing the personal data for the purpose that we require for. So the first and foremost requirement of a consent is that the consent must be backed by a privacy notice. Privacy notice is nothing but an information that the organization shares with an individual about how it will process the personal data. It is through this notice that it shares information about its processing activities with the individual, the purpose of processing, how will it use the data, whether how will it disclose the data, who are the recipients of the data, what are the measures that it has been implemented to safeguard data, what are the grievance mechanisms available to an individual. All these aspects will be set out under a privacy notice. So the intention of the legislature here is to ensure that the individual is well aware about the use case scenarios and what the organization will do with its data. So it wants to ensure that individual is well aware and takes an informed decision and then provides the consent. So privacy notice is the key. Consent must be for limited for a specified purpose. So our we should identify the purpose well in our privacy statements, that what is the purpose that we are obtaining the consent for? What is the purpose that we would be processing the personal data? So let's take an example. So for example, I as an individual apply for a course in some institute, and there I understand that the institute will be using my personal data for registration purpose and for any other formalities that are associated with the course. And that is what is being shared by the institute to me. Now, tomorrow, going forward, the institute shares my personal data with some of its affiliates who are also into providing student loans, or with other educational institutes with which it has tie-ups, or any institutes which provide any further diversified courses. So here the consent which has been obtained only for registration and for the registration purpose, and only for provide for the formalities which are associated for providing me with the cost, would be void when this data is being shared with other third party providers. So the purpose of the data should be identified well, and consent should be obtained only for the limited specified purpose. The consent should be free, specific, and informed. There should not be any conditions attached to the consent. So there should not be, it should be unconditional. They should not say that, okay, you give me a consent and you earn these many reward points or you earn these prizes. It should be clear. It should be provided in a clear, plain language. Also, it is important to note that withdrawal of consent should be very easy. The way we provide our consent by clicking a checkbox or any button. Similarly, there should be an ease of withdrawal of consent. So consent should be easily withdrawal by writing an email to the organization, or selecting a checkbox for withdrawing of consent. There should be a clear affirmative action. Gone are the days where there would be, you could see a pre-signed, pre-ticked checkbox, or the notices being provided in lengthy verbiages and verbose and too much of legalese. It should be clear. There should be an affirmative action. The user should be allowed to either check box or provide a signature or do some action when it's providing a consent. Similarly, the consent must be provided in local languages as well, where we are providing certain services in a particular area where the people are not aware of the English or any other language. So consent and notices must be provided in regional languages. We are set to get more clarity on this aspect with the rules which are slated to be released at a later date. And finally, we should have an evidence to retrieve the consent. So here, technology will play a greater role, where we would base this on the technology. We will be able to demonstrate that we had obtained the consent and also provided an opportunity to the user in relation of providing a privacy notice to a user. So technical and technological implications about providing a notice or maintaining logs of these consent would be further dealt by Manoj in the later part of the segment. Next slide, please. Having spoken about consent, let's quickly check about the privacy aspects that are associated with the privacy notice. So, as I said, that consent should be backed by privacy notice, and the purpose of privacy notice is to inform the individual about the activities associated with the personal data that the organization will be doing. So, basically, the contents of the privacy notice should include the types of personal data collected, the purpose of collection of personal data. We spoke about the mechanism of withdrawal of consent. Similarly, the privacy notice should highlight or provide details about the grievance redressal mechanism. Here, the law makes it very clear that an organization should provide the individual mechanisms to raise their grievances for any activities that are the individual feels that are not in compliance with the requirements of law. Similarly, the details of the compliance officer or a public point of contact or the DPO should be maintained, provided in the privacy notice. Along with it, there should also be a provision wherein a guidance is provided to the individual how he can raise any escalation to the Data Protection Board of India. So these were few of the requirements associated with that should include in a privacy notice. Next slide, please. There is one more interesting fact about legacy data. So the law wants to make it clear that as the law is not being enforced, so the act says that once the law is enforced, any organization that has collected personal data and sits up on a legacy data or which is consented or non-consented. So for that data set, it becomes mandatory for the organizations to refresh their privacy notices to such individuals upon the commencement of the act. So once the act is enforced, organizations will have to reshare their privacy notices with the individuals or their earlier users whose data they are processing. So similarly, there is an example which states that I X as an individual who has given their consent for processing personal data on any app or a store or an e-commerce platform. Here, upon the commencement of the act, the author, the app owner or the platform is required to provide the privacy notice to the user describing its processing activities. So this is another obligation which is there that needs to be taken care when we are dealing with any legacy data that organizations sit upon. Next slide, please. Okay. So, having understood one ground about consent, let's understand the other ground, that is legitimate use. So, the law understands that there would be certain scenarios where obtaining consent from an individual would be difficult, and still we need to process personal data of that individual. So these could be scenarios in relation to, so suppose when there is an epidemic or an outbreak or any other health threat. So any health services which are provided during this activity and you are processing individuals' personal data. So that kind of an activity would be termed as a legitimate use, and you may not obtain consent. So all the activities associated with providing any assistance during any disaster or management. So there in that case or any medical emergencies would fall under the legitimate use criteria. Similarly, any disclosures that you are required to make to the government as part of any proceedings or any requirements of the law would come under the category of a legitimate interest. Accordingly, personal data which is voluntarily provided on public platforms, we discussed that earlier with the examples of personal data shared on social media handles or voluntary provided in the public domain on MCA websites are would come under the under the ground of legitimate interest. Similarly, activities in relation to government subsidies, benefits, certificates, or performance of any functions. There are certain compliance requirements in association when an employer, in case of IPR related claims or espionage, would also come under the ground of legitimate interest. So here, what we can conclude that processing of personal data, apart from these activities, should be solely relied upon consent. Consent acts as a king. All the other grounds or these use cases would fall under legitimate uses. So, but when an organization processes personal data on a day-to-day basis or to meet its daily operations, hardly these activities which fall under the grounds of legitimate uses are considered. So, the only ground for processing personal data as part of an organization, as part of its daily activities as concerned, is consent. Next slide, please. Having understood about the grounds of processing of personal data, let us understand what are the key obligations on an organizations that process personal data as a data fiduciaries. So here it is important to understand that under this act, these are the direct obligations on data fiduciaries. So when you're playing a role of a data fiduciary, you need to ensure that your processing activities are based on certain grounds, that you need to determine that you are able to demonstrate that you obtain consent. So your grounds of processing, if you're relying on consent, then the aspects in relation to notice, consent, ease of withdrawal of consent should be taken care of. You are also responsible to maintain the completeness, accuracy of personal data. As an organization, you are responsible to ensure that the personal data is processed only for a specific duration or for the specific purpose. So data is not retained perpetually. We've seen that organizations lack this understanding. They retain personal data for a perpetual period. The act says that once the identified purpose of processing is complete, you need to erase that data. You are not required to retain the data for perpetuity. Similarly, once you as an organization are required to implement security measures, technical measures at an organization level to safeguard the personal data in your possession. There are certain obligations. This safeguard needs to be done to prevent personal data breaches. In the event of a personal data breach, there are certain obligations associated with personal data breach. There are in relation to personal data breach notification. So, as an organization, you are obligated to notify to the Data Protection Board of India as well as the individual. So, you have to have mechanisms in place, processes in place to meet the data breach notification requirements. You need to have well identified timelines. Key stakeholders must be identified. Your processes in relation to breach mitigation mechanisms should be robust when it comes to data breach notifications and things like that. Similarly, the other obligations are in relation to appointment of any POC or a person that would be responsible to address the communication received from data subjects, the data principals, or the regulatory authorities. Last but not the least, it is very important to have valid contracts with the data processors. So here it becomes very important to understand that under the Act, there are no direct obligations on the data processors. An organization that is a data fiduciary is solely responsible for the processing activity conducted by a data processor. So a data fiduciary will be directly held responsible for any data breach that has been occurred by a data processor. If there is any unauthorized use or disclosure of data by a data processor, the entire liability is on the data fiduciary. So it becomes very important from a due diligence perspective, a vendor due diligence perspective, that you need to ensure that your appointment of vendors or your selection of vendors is backed by robust mechanism, robust due diligence process. You should have robust contracts, because these would only be a way where you would be able to mitigate the risks that would arise out of the liabilities in relation to the processing done by the data processors for any non-compliance of the Act. So here it is important to have robust contracts to mitigate such risks. There are certain penalties for non-compliances. We will be dealing those at a later stages of the slide. Next slide, please. Okay. Having understood the obligations of the data fiduciary, let's quickly understand the rights and duties associated with a data principal. So under this act, the data principal has been awarded with four rights. There are four rights which has been recognized. The first is right to access information about personal data. So I, as an individual, can raise a request with the organization when I want to understand what type of data the organization is accessing, about its processing activities, and where and how the data is being used, disclosed. So all the activities that an organization undertakes in relation to my personal data, I have a right to ask that organization to help me understand how the organization is using my data, and I can use my right to access information about my personal data. Second is right to correction and erasure. So a data principal has a right to ask the organization to correct as well as erase this personal data. The third right is in relation to right to grievance redressal, wherein if I want to raise any grievances against the organization should ensure that it has a mechanism through which I can raise grievances. The fourth and final right is right to nominate. Here it becomes very important. This is a new right under this act, which states that I, as an data principal, can nominate an individual in the event of my death or incapacity to exercise any of these rights against an organization. So, with these rights, it is important that businesses or organizations, the data fiduciaries specifically, need to ensure that they have the necessary processes and protocols to meet or adhere to these rights which have been exercised. Just imagine a data erasure right exercised by an individual. So it becomes very important to first map the data, identify where all the data is lying to meet the requirements of the right. It becomes very important to understand what would be the consequences of deleting the data, what would be the consequences of not deleting the data, whether you could reject this request of deletion of data, what processes needs to be changed, what technological aspects needs to be implemented to address this rights. So a lot of technological dependence also is there when we as an organizations are required to meet these rights which have been exercised. We'll also be covering the technological aspects by Manoj in the next slides in relation to data subject rights as well. So yes, the organizations would have to be geared up with having a procedure. They'll have to meet certain timelines in meeting the rights. The timelines are yet to be notified, and we'll see at a later stage. Yes. Next slide, please. So, having understood the rights, there are certain duties which are there on a data principle when you are exercising your rights. So, these are that you should not suppress any information that when you are submitting any documents to the government. So, you should not suppress any material information about yourself when you are providing any documents to the government. You should not impersonate any other person when you're exercising the rights. You should not raise any false or frivolous grievance or complaint, because with the rights and with the mechanism of grievances, easy grievance redressal mechanisms, there could be a rise in raising frivolous or false complaints. To keep a check on this and to ensure a data fiduciary is not being bombarded with requests which are false, or address any grievances which are false in nature, there is a duty that you should not raise any false grievance or complaint. And similarly, you should furnish only that information that you can verifiably authenticate through some evidence. Similarly, non-compliance with the duties of a data principal, there is a penalty of 10,000 for the same. Next slide, please. Having understood the obligations of the organization, the rights and duties of an individual, let's quickly understand the regulatory and enforcement mechanism. So, the first, so an individual has a right to raise a grievance against an organization. If at all the organization is not able to satisfy or address the grievance, then the individual can raise the grievance with a Data Protection Board of India. So the Data Protection Board is a regulatory body. Here, it is in the form of a digital office. So simply by writing an email to the Data Protection Board of India, an individual can register or raise its complaint or grievance once it has already utilized the recourse of raising the grievance with the company. This digital office, so there would be a chief executive will be appointed by the central government. The Data Protection Board will have wide powers to investigate various issues in relation to non-compliances. They will also have the powers to impose penalties, calculate the penalty, the financial penalties. They'll get to decide how what is the nature of the penalty, and accordingly raise the fines, nature of the grievance, and accordingly raise the penalty for the instance. So these are few functions and powers of the Data Protection Board of India. Having understood about the regulatory and enforcement mechanism, let's understand the penalties for non-compliances. Next slide, please. Okay, so there are certain financial penalties associated with non-compliances. Here on the screen, you can see the highest number of 250 crores, but that is not the case. Under the Act, the penalties do not have a higher cap. So, as under the GDPR, as you must be aware that the penalties are capped to 2% or 4% of your global turnover, or 10 or 20 million. Here, there is no cap. How is that? So, like for example, if there is a data breach happening, so here in as part of a data breach, if it is found that the organization has failed to notify uh, the individuals, or has failed to comply with the notifying obligations, then it will be fined with 200 crores. It further During the investigation, we also understand that there are no security safeguards that an organization has implemented. So the fine could go higher. It could go to 250 crores plus 200 crores, that is 450 crores. And similarly, if there are any other, uh, during the investigation aspect, if you realize that there are any other provisions also which have not been implemented, which have caused a data breach, would also be considered. So in one event, all these fines may be accumulated and the number will go more higher. So it is very important from an organization perspective to at least ensure that you have a baseline framework, or aspects wherein you can at least state that an event which led to a data breach, you were at least diligent in having certain security safeguards implemented. And accordingly, your fines and penalties would be calculated. Having discussed the financial penalties, let's finally discuss the key takeaways. Next slide, please. Yes. So, what is in store for an organization here, having understood the compliance requirements, having understood the rights, we also spoke about the penalties. So, it is very important uh, to assess your preparedness. So, it is very important to understand where do you stand in relation to compliance with the requirements of the law. So once you've done your assessment, it is important to have a framework established. This framework will help you meet the compliance requirements of the law. So you should have a framework which is a mix of all the processes and policies to meet the requirements of notice, consent. You should have a proper framework to map your data. You should have mechanisms in place to have to mitigate data breach kind of incidents. You should have proper policies for data retention. Your vendor management should be up to speed. So all this privacy framework will help you meet the compliance requirements of the law. The privacy framework would depend on some technological dependencies, which will be spoken by Manoj at a later stage. Having a framework also requires periodic audits, and if there are any non-compliances, you need to have the remediations. And as we said, also have certain security safeguards to prevent incidents like data breach. So having understood about the DPDPA from an organization perspective and from a legal perspective, it is also important to understand DPDPA, what is the impact of DPDPA on various sectors. So let's touch base on the sectorial impact on the next segment, which will be taken up by Janardan. Over to you, Janardan.
Thanks, Karan, for that wonderful insight. The understanding of the law for general public couldn't have been better with your holistic assessment. So, ladies and gentlemen, after having understood the complete spectrum of the law, the common question comes to anyone's and everyone's mind is how does it impact me? So, in next about 5 to 7 minutes, we will be analyzing the impact of this act on common people and organizations. Friends, first and foremost, with the implementation of this law, the privacy rights of an individual and organization are definitely going to get enhanced. As Karan brought it out, there are certain rights as well as duties of data principles. The same are likely to definitely impact the functioning and overall understanding of the subjects. The legal recourse which is available to anyone and everyone is likely to get modified. At present, before prior to 2023, there was no definite legal framework as to which particular board to approach. The same has now been constituted as per the act, and that legal recourse is available. Impact on businesses, a very important aspect and maybe most critical. We all are very savvy about what is the impact on my business if I comply or not comply with this particular act. So, as brought out by the legal expert, the penalties are likely to be severe. Hence, the impact on businesses is going to get affected by this act. The transparency requirements which are associated with the implementations are more in number. So the organization will have to be absolutely transparent with respect to the data collection, processing, and subsequent utilization. And last but not the least, the erasure part. The security standards which are required to be maintained by an organization are likely to enhance in its standards. And also, with all these factors impacting, the training and awareness in form of educational efforts for any and every organization is also likely to be more. So friends, all these 5 6 factors which I just brought it out are common for, they are impacting all of us. They are for all common people and organizations. These are 5 6 factors which we have listed, which will be common impact points for all sectors: the data collection and processing, the security measures implemented, the legal and compliance cost. So every organization will have to bear some legal and compliance cost with the implementation of this act. Consent and transparency, the point has already been brought it out in much larger details. Suffice to say that consent and transparency will have a major role. In fact, it will be a starting point of implementation of this law. Training and awareness I have already covered, and the consumer trust and reputation is definitely will be at stake while implementing this. So all these points will have a common impact on all the sectors. After having seen, we will now analyze 3 or 4 important sectors which are likely to get impacted. First and foremost is software development oblique IT consulting. At present, there was no definite framework for this. So hence, this industry will have to work now on developing or deploying any product by privacy by design principle and zero trust architecture. The people who are working in software development, information security, and cyber security will definitely understand it in more detail, that the impact on software architecture is likely to be more. The legal and regulatory expertise which is required to be associated while developing the particular software is also likely to be more. The third party risks for non-compliance, I already brought it out by Karan. If a particular of your partner is not complying with the particular act, then this associates with the third party risk. People who are into this field definitely need to take this into consideration. The fintech services and insurance, the BFSI sector, the famously called as, it is also likely to get impacted under following heads. We all know that there is a data breach notification guideline by the Reserve Bank of India, which tells or guides the organization to report a particular data breach in a definite time frame. So this, along with coupled with the existing provisions of the act, are likely to impact the fintech sector. The regulatory alignment and challenges, along with the partnership and vendor management, wherein there are multi-party transactions involved in fintech services, will also get definitely affected. The famous HR or the people's department, in which this act or law is also likely to get affected, wherein we have impact on recruitment. All the HR teams are collecting PIIs, personally identifiable information. There will be an enhanced role for the learning and development department as it is found in all typical HR departments. How the manufacturing sector is likely to get affected, friends? There are supply chain implications on manufacturing because there is a chain of supplies which gets developed while one is in manufacturing sector. So the cascaded effects of compliance oblique non-compliance will definitely affect the parties which are in manufacturing sector. Education. The impact on educational technology, that is EdTech, is also likely to get affected, since this law has a stringent provision for complying with collection of children's data who are less than 18 years of old, in which parents' consent has been made mandatory. So therefore, processing of children's data assumes equal importance. After having seen the sector-wise implementation, now it is worthwhile to see how the technological impact will assess and see this act getting rolled out. For this, I hand you over to Manoj, who will be bringing out the technological implementation part. Over to Manoj.
Yeah, let me know once I'm audible. Am I audible?
Yes.
Okay. So thank you so much, Janardan and Karan, for all those super useful insights from legal and sectoral perspectives. Um, so what I'm going to cover quickly are these points. So let's say you're building a website, or you are creating web application, or you are creating, or you already have a mobile application. So from that perspective, I'm going to cover a few points. I'm quite sure that in such shorter time, we won't be able to cover everything that is needed to actually implement it from tech perspective. But I'm going to quickly highlight few points which we feel are important ones. Uh, so we'll start with assessing where do we stand. So as a business, where do you stand in terms of data collection? Like what different data you are collecting, processing, and storing as a business that you didn't, yeah, that definitely want to assess. Um, so in terms of data collection, we suggest that you go minimal. Ask twice that do you really want those many number of fields on registration form? Can you go minimal? Is the every single field that you are collecting, is that really important? And you need to basically determine the legal basis for processing each data that you are collecting. And once you are quite sure that these are the data fields that you need to collect, then you need to put in your privacy notice in consultation with your legal team or partners that this is your privacy policy or notice, and then uh, put that into your mobile application or your website or whatever medium that you are running your business in. Uh, so to just to give a quick idea, although the law does not categorize the PI data in such format, but just to make it from the storage point of view, it can be categorized broadly into these two things: sensitive PI data and non-sensitive PI data. In sensitive, the things like Aadhaar number, financial account details, PAN number, your health records, biometric information, the pin numbers that you said, those could we could categorize those as sensitive PI data. And in non-sensitive one, you could say names, addresses, phone numbers, emails, username, which typically we use for logging into particular systems. Um, so once you identify what PI data that you are collecting, you put that into your privacy policy. Uh, the privacy policy, as covered by Karan earlier, so it has to be definitely easily understandable. It has to be very crisp and clear. The consent that you are going to take, the consent mechanism has to be very explicit. The consent instructions have to be very clear. And since you are supposed to take it in English plus some regional languages where you are running your business in, a, a very simple example of doing that could be like this: that you only have one privacy page and you do show the terms and condition in different languages like this. You also need to establish some sort of procedures on how you are going to take consents for the guardian in case of minors, because the law says so. And since by law you're required to keep at what time the user has given consent, or at what time your user has withdrawn the consent, we suggest that you definitely keep log of consent given and consent withdrawn. So for the developers who are online, I mean, this is very rudimentary database design that you could implement. So very important points for consent management that could be required is because your privacy notice or policy may change over the time. That's why you should definitely maintain versions of it. So you'll definitely have versioning, and from what date the next version will be effective. Uh, and to track what all which all users have given consents and at what point in time, maybe you also want to track the consent given date or timestamp, and against what version of privacy policy that consent was given. So this will definitely come in handy if anything goes wrong in future. So definitely keep track of all the consent given and withdrawn. Also keep in mind that you may need to implement some kind of auto revoking consents mechanism if you want to roll out the next version of privacy notice. So let's say the next time user comes in, if he has already given consent, which is reopened, so you are again asking for the consent to be given. Next slide, please. So once you are done with the consent management, think of how you are going to store the set data, all the PI data. So you may need to, so if you are building something from scratch, or if you already have some system in place, maybe you need to think or rethink based on that from privacy and security perspective. Uh, for all the aspects of your system, including the database design, the API design, the UI implementation, your server-side infrastructure, all of that has to be reconsidered from privacy and security by design perspective, where you may need to architect or re-architect your system in a way that it understands what PI data it is collecting. And definitely for the sensitive PII data, we recommend that you store that it in encrypted manner. Again, a very rudimentary example that shows how uh, things like example like PAN number can be stored in encrypted manner. In addition to that, so this is the data that you are storing on your own servers, but the things like what kind of security measures you have taken for cloud storage like AWS S3 bucket. So whether those are private, public, who can access data from that such kind of storage aspects also you need to think of and revisit. Uh, so on data storage and retention, so like earlier mentioned by Karan, that once the purpose of the data collected, that purpose is achieved, you might want to think about whether you want to still continue storing the data. So maybe you need to rethink about the entire data cycle and think of what all data can be deleted if its purpose is achieved or fulfilled, or what if the consent the user has given has been withdrawn. So that particular thing also, as a developers will need to keep in mind. So here is in the screenshot you can see example of one of the tool that we had built earlier when we implemented the GDPR related suggestions. So this tool was a reporting engine, and that reporting engine was aware of what different PI data that is there in the report. So, and that PI data we used to show based on the user's access based on his role. So designing a system that is aware of PII data in conjunction with role-based access would be very critical to implement this act. Now talking about how do we implement different rights of data principles. So if you have used Facebook, for example, provides these ways to access your information. Like if you go to your account settings, you will see that there is a way to access what data it has collected. There is a way to download the data that Facebook has collected. Also, there is a way to uh, nominate uh, in case you are not able to access your account, or what would happen to your account or your data after uh, let's say your death, for example. So all those things we need to address. So right to access information, right to access personal data. So you may need to think of how you are going to implement this. uh, so you may not implement, to begin with, you may not implement very fancy thing like what Twitter or Facebook does, but maybe a simple CSV export of the data of particular user, or that kind of mechanism you might want to think of. Then the right to correction would be ability to edit whatever data I have provided and make correction into that. Sorry. Then you may want to implement some sort of help desk kind of mechanism to for addressing various grievances that are reported by your users. And the final slide that I am going to cover is how do you basically prevent data breaches? So again, a very broad topic. It on its own will need another webinar, but regular security audits will definitely help preventing data breaches. In addition to whatever that has been covered so far, implementing suggestions from those audits. You need to prepare for worse. That let's say what if the data breach occurs? So what different things you may need? So you will need a way to notify your users that some mechanism to notify that there has been a data breach, and you will need some mechanisms to contain the data breach, like then whatever is needed to fix the breach and implement learnings from the previous breach so that the similar incidents don't repeat in future. And then once that is done, you need to educate your internal team, even your clients, that what are the learnings from this incident and how do you educate your team. So um, some sort of SOP will need to derive from that. So yeah, so like I said, we could consider whatever I said as a starting point. Definitely there is lot many things to cover and lot many things to implement. These are just very broad level things that we talked about. So with that, I would like to hand it over to Janardan again, and then we will open session Q&A. Thank you.
Thank you, Manoj, for that insightful session on the technological aspects. With this, ladies and gentlemen, we have come to the end of the proceeding as far as the speakers are concerned. I know that we have exceeded our time limit. However, you would appreciate that the extent of this particular topic is so much that we have to really struggle to meet up with the timelines. If you have any questions, please, I will request you to give out your name, your organization name, and if you are comfortable, please switch on your camera and ask your question.
Hi, this is Rishikesh. May I go first?
Yeah, please. Please,
Yeah.
Rishikesh. Yeah.
I'm starting my video as well. Am
Yeah,
I
please.
am I
Yeah.
visible?
Yeah, go
Yeah.
ahead, please, Rishikesh. Yeah.
So I'm Rishikesh from My Next Hire Private Limited.
Okay.
I have a question it's technical question. So does this act say that we have to store the users' data in India only and not outside India?
Maybe Karan, you would
Yeah,
like to take on
I'll
this?
address this. So, this act has no restrictions in relation to data localization as such, but there are certain other regulatory acts, like say, for example, regulated entities under which are under the RBI. There is a requirement to retain POS kind of data, regulated data in India. Otherwise, apart if you do not fall into the category of a regulated entity where you are bound by any regulations of RBI or insurance for that matter, then in that case you can store your data outside India also. Similarly, there is no restriction on data transfers outside India, only in countries that have been marked under the negative list or which with whom the relation of India is not that great, which would be notified, which fall in the category of a negative list. There you cannot transfer the data. Otherwise, there is no restriction on storing data outside India for a normal organization.
Okay, that answers my question. Thank you so much.
Okay, Shoaib.
Hello.
Shoaib, please unmute yourself. If you're comfortable, please switch on the camera and ask your question, please.
Yes, hi. Hello. So
Yes,
just wanted to know that in respect of the NGOs, right? So who will responsible for the oversee the data protection policy? Do we need to appoint an data protection officer, something like that, or what?
Shoaib,
Yeah, may I
Shoaib,
go ahead, Janardan?
yeah, please, Karan.
Yeah. Yeah, so Shoaib, it is ultimately the obligation on the organization itself, the NGO. Had it been categorized under a significant data fiduciary, I doubt that would be the case, but let's wait for it. But yes, it is the responsibility of the NGO itself to have security safeguards in place, to have processes in place to so that they can meet or mitigate the risks that would come out from a data breach kind of a situation or an unauthorized data disclosure. So the law makes it very clear that any organization, any person who is processing data has to own the responsibility of protecting that data. Data protection officer is at this point of time, appointment of a data protection officer is basically on a significant data fiduciary. The data protection officer will be responsible for liaising with the regulator and and also addressing the data subject or data principles query. Other than that, it is the organization's responsibility to implement security safeguards.
Okay, yeah. Thanks, Karan.
So, yeah, next, Sudha, please unmute yourself. If you're
Sure,
comfortable, switch on the camera and please ask your question.
sure. I'm Sudha Upadhyayala, and I represent 1 Billion Retreats Foundation. We are an
Okay.
NGO working in education sector and health sector. So we collect data about patients as well as children in the schools. So how do we put in place a proper, data protection guideline and policy? The second is we also collect the details for donors. We have to send quarterly reports to them. So how does this law apply in that case?
So
Uh,
here again, there is no specific treatment under the law that is being given to an NGO or any other organizations as such. So when it comes to obtaining consents, like if you're processing children's personal data, there are certain aspects associated or additional compliance associated with obtaining consent. So you will have to have your mechanisms in place where you can at least demonstrate the consents that you have obtained, and also have your notices drafted in a way that the provider understands the purposes of this data. Similarly, when it comes to donors aspects also, uh, the donor should also understand very clearly that what is the purpose of the personal data being utilized by the organizations, and he should be provided with an uh, with ultimate information about the processing activities that are associated with.
Got it. Thank you, Karan.
Ashwini, please ask your question.
Yeah, hi, this is Ashwini Vadavekar, and I am from Inspirit Vision, a cybersecurity organization. So in Karan, your slides, you had mentioned about assessing the preparedness and also, doing regular security audits, establishing a framework. So I just wanted to understand, assessing the preparedness, is that the organization, the data fiduciary themselves who should do it, or is it through some legal and compliance team that it should be done, or
See, assessing, what do you mean by assessing the preparedness is basically to understand where currently you are in relation to the compliance requirements of the law. So when I say assessing the preparedness, you will have to map all your activities with the compliance requirements. And there you may need help from a legal or a legal expert, where that legal expert will help you understand that these are your current activities currently, and these are the requirements of the laws. So vis-a-vis the requirements of the law, where do you stand? So if, for example, you are already complying with certain framework, so you may require to make some additional tweaks, or if at all, if you have nothing, you may need to get started with the scratch. So this assessing impact assessment or privacy assessment is basically kind of a check that that will help you understand that what additional you need to do in relation to meeting the compliance requirements of the law. And with the enforcement date yet to be notified, we see organizations have already undertaken this activity of conducting impact assessment to understand what changes they need to do of their current operations to meet the requirements of the law.
Okay, so a follow-up question on the same was like regarding the audits. So is that the InfoSec audit, or is this DPDPA audit something different? Like, because
audit-
InfoSec is a typical information security ISO 27001 kind of audit.
Correct. So audit here has a broader perspective. Here, the reference of audit is to understand and check whether the processes and policies that you have implemented at an organization level, which form a part of your privacy framework, are being put to test or being put to use in a right manner or not, or is it just on paper? So it is important to know that whenever there is a data principal rights which has been said, what all things that you are required to do, so that audit will help you understand whether the required checks and balances are there in place at an org level to meet the privacy requirements. Infosec is a separate thing that would deal with your infosec information security controls, but these audits that we are referring to is in relation to compliance with, see, ultimately, the law says that you should be able to demonstrate your compliance when you are being asked upon, or whenever there is an investigation. So an audit check could be that, okay, I am obtaining consents. Do I have a record? Do I have a log of it? So that audit will help us understand whenever the audit is done to verify the consents or evidence. That audit will help you understand that yes, the logs are maintained of the consents, and thus I'm meeting the requirement of the law. So that is the purpose of the audit, basically, to give you a check of your compliances.
Okay, thank you.
Yeah, Vidyavati has posted. Can you elaborate on legal and compliance cost? Karan, any comments?
Yeah, see, ultimately, this is a two-phase thing. Like, cost, as in relation to, it all depends where you begin with. So, if you already have some framework in place, then depending upon your maturity, your cost would be determined, and depending upon the operations, depending upon the nature of personal data sets that you access, depending upon your processing activities. So it is not a direct, I may say, an easy answer that this would be the range of doing the compliance from a legal and compliance or information security perspective. So it will all depend upon your current posture and your current maturity of the framework that you've implemented. So there, impact assessment or privacy preparedness will help you determine that where do I stand and what would be the cost as such.
Thank
you.
Vidyavati, probably the second aspect to your question will be, you see, you have to look it from the perspective of running like a race. For example, you want to run a race. So firstly, you have to assess that where you stand presently. So based on which your preparation will, it will take that much time and effort. So you have to look it from that perspective. So the answer to your question will be, it will completely depend upon your present status of your organization and which stage you would like to go in and in which time frame. The complete thing will depend upon that. Yeah, Shweta. Yeah, thank you, Shweta. Probably Manoj, you can answer this. Can you please elaborate the data localization requirements?
So as I earlier said, there are no specific requirements for data localization unless and until you are a regulated entity or you are dealing with regulated data sets. If for a normal organization, the data can be stored outside India and can be shared across India as well.
I think this answers to the next question also. Rushikesh had asked, does this act ask us to store data in India servers only? So I think that has also been answered. Colonel Vinod Peragu, sir, how do you think government will be having checks? Sir, Karan has already brought it out, the constitution of a particular board, data protection board. As per the recent updates by Mr. Ashwini Vaishnaw, the Honorable Minister, this board is likely to get constituted in a very short time frame as per the reports in the open source. So as I understand, this board will act as a checkpoint for Government of India. Karan, any further comments on this?
No, you covered it well.
Yeah. So the second question from Vinod sir was, as per the latest Bharatiya Saksha Adhiniyam, how data protection officer of the organization will defend? Karan?
So defend.
I think this is the
case-
replacement for the
Yeah.
Indian Evidence Act 1885, if I'm not wrong.
Yes.
Yeah. So do we have any clue on this, that how the data protection officer will defend in the context of the latest Bharatiya Saksha Adhiniyam or the Bharatiya Nyaya
So see
Samhita?
here, the data protect the job of the data protection officer is very limited as such. So any which ways it is implementing compliance requirements is the obligation of the organization as a whole. It is not that a data protection officer will only come to defend for any non-compliance as such. So there are limited responsibilities on the data protection, whereas entire obligation for compliance rests on the organization.
Yeah, Rushi Gawai, he has asked from YouTube Live, which is concurrently going on. Do we need verification for our website's privacy policy, terms and conditions, and data policy before publishing? Also, must changes be reported to the government, or can we manage this internally?
No, yes, verification as in validation. If I'm getting your question correctly, yes, the privacy notices would have to be revised as per the requirements of the Act. And once revised, you'll have to update it so that on your website with the latest notification date, so that the user also understands that you have refreshed or updated your privacy notices, but there is no requirement of notifying the government.
Okay, hope Rushi, we have answered your question. Sajal Das from Piramal Foundation is asking, what about the data sharing by the government to the NGO for further processing and enhance indicator? I'm not clear about the last part, but yes, Karan, may I request you to take on this? How the data sharing by the government to NGO for further processing will affect?
Yeah, so here also government has uh, uh, if there are certain aspects in which the government is being exempted, but on a whole, the it is not that entirely the government would be exempted from data sharing from the compliance obligations, but yes, they will also need to comply with the requirements when it comes to data sharing. But there are certain instances where, in case of sovereignty, security of state, there are certain exemptions on the government. So, but otherwise, they would have to comply with the requirements of the law.
Yeah, I do not think there are any more questions. So, ladies and gentlemen, we know that we have exceeded our timeline by almost by half an hour. But I think with the kind of discussions, the kind of questions which were originated in the question and answer session, it was evident that you all have shown great interest in our introductory webinar. My only request to you is to do share your feedbacks and suggestions. If you want Tekdi Technologies Private Limited and LegaLogic to have any further webinar on dedicated to any specific topic or any content, please let us know through our email IDs. We also have our contact numbers displayed on the screen, both the firms, LegaLogic as well as Tekdi Technologies Private Limited. You can also scan the QR code, note down the email ID and contact us. Ladies and gentlemen, in my concluding remarks, I just wish to say that this was an awareness session aimed at generating awareness. So the only question we all need to ask to ourselves in our personal as well as professional capacity is that, are we DPDPA ready? I think we leave it with that thought. Thank you so much for attending this webinar and showing your time and patience. We'll see you in the next series of webinar as per your request. Thank you. Good night.
Thank you, everyone.
Thank you.